This is Michael Popok, Legal AF After Dark. You like lawyers who know what they're talking about at the intersection of law, politics, and justice? Come, follow, watch our show, Legal AF. On this past midweek edition, we do it twice a week, we explain, debate, and explain what is going on with all these immunity cases related to Donald Trump. What is immunity? How is it different, civil versus criminal? And why did the Second Circuit Court of Appeals in the E. Jean Carroll second defamation case against Donald Trump, why did the Second Circuit Court of Appeals find that Donald Trump waived his right to assert immunity? It's a head scratcher unless you regularly follow Legal AF. Take a listen to our most recent episode. Three of us is that we've got another appellate decision, federal, this time the highest court in New York, the Second Circuit Court of Appeals, ruling today. I mean, I don't like to wrench my shoulder patting ourselves in the back, but we did say that this was going to happen, which is the E. Jean Carroll case. Donald Trump finally got around after 3 years to trying to assert late presidential immunity. I'm immune. You can't sue me for the things that I said when I was president, when I said these terrible, horrible, horrific, defamatory things about the person that I have been adjudged already to have raped in April of, or the spring of 1996. You can't do that. I have immunity. To which we, you, me, and Ben all did hot takes because we got the oral argument off the Second Circuit and listened to Alina Habba gurgle, flounder, I know I'm mixing metaphors here, drown in response to questions from a very hot bench. And one of the questions that was asked particularly, which showed up now in the ruling, which is that Donald Trump waived any argument that he's immune from suit because he raised it too late, that it's a waivable thing. You either you use it or lose it, and you got to use it fast early on in a case, and don't get 3 years into it and then say, oh, I just remembered, I used to be the president, presidential immunity may apply. And there was a back and forth with one of the judges for the panel to Alina Habba, and she said, well, your argument then is that presidential immunity in the civil context can never be waived? No one can ever waive it? It's no. And Alina, no, it can never be waived. It's automatic. It's almost like it's self-executing. Who would ever waive? It can't be waived. And the judge said, well, I can think of some scenarios where a president, maybe not your client, wants to waive any aspect of immunity because he wants his day in court to clear his name about allegations and doesn't want to just rely on immunity. And to Alina Habba, that was such a foreign concept that somebody would actually want to go to trial, testify, and clear their name. But she was like, it was almost like flatlined. You could see the smoke coming out of Alina Habba's ears on that. And that became an animating force when the judge today, I think it was Judge Cabanis, right?
Yeah.
I think Jose Cabanis used to be on the Southern District of New York, a trial level judge, as most of them are, and then get elevated to the Second Circuit, along with Denny Chin and one other judge that just escaped me. He wrote, it's waivable. It
Khan.
is which is the third one?
Isn't it Khan?
Yeah, Khan. You're right. And I think it was Khan that got into it with Alina Habba during the oral argument. And right out of the box, they said, this is a case of first impression. And the fundamental question is, do you have to raise the affirmative defense of presidential immunity early on in a case, or have you waived it? And they said, you waived it. 3 years into a case is way too long for you to say that you are now asserting the privilege after you've lost the prior trial and all the other, and on your third filing, your third pleading 2.5 years into a case, you finally got around to growing a brain and figuring out that maybe, oh, right, I was president. Maybe I should raise that as an immunity. And they didn't buy that. And there's really no good explanation. One of the reasons that as a trial lawyer, you don't sometimes do your own appeals and you let another law firm or lawyer do your appeals is because sometimes there's some very difficult questions that are asked about what you did at the trial level. For instance, why didn't you file it earlier? Now, if you're the appellate lawyer, you can say, well, the record is unclear as to why the trial, that's of no moment. Here, you got to go, I didn't do it because, and it becomes problematic. I've been in appellate arguments about cases in which the appellate court actually said, I know it's not in the record. Now, they're not supposed to do this, but they do it all the time. I know it's not in the record, but what really happened? Was there a posting on social media or wasn't there? And I'm almost like, you're not supposed to ask me that question. It's not in the record, but they do. They're human beings. They're trying to reach a proper decision. How did you read? I know you and Ben did a hot take on it. Jump in. Tell me why, for instance, some of the people now, like tonight, are saying, I don't get it. In criminal immunity land, in the world of a criminal prosecution, everything stops while the immunity issue gets decided on appeal. That's what you just told us, Popok. Chutkan stopped the trial. Why then, if it's so fundamental to the jurisdiction of the court, why then, at least in the civil context, does the former president, have to raise it at all? Why isn't it automatic? Why does it matter when he raised it? He raised it, and therefore should have divested the court of subject matter jurisdiction. And I say, good question, chat. Turning it over to Karen.
Yeah, this was a head scratcher, just because, there's how many, what did we get? 3 or 4 decisions on presidential immunity, or opinions on presidential immunity in like 3 days. I mean, it was just crazy that these are all coming down at the same time and talking about the same issue. So, don't forget, we had Blasingame, right, which is the civil case in Washington, D.C., where it was Capitol police officers and others suing Donald Trump for January 6th, and that presidential immunity, and that's a civil case. Finally, that decision came down like an hour before Judge Chutkan's criminal presidential immunity decision came down. And then now we're getting the Second Circuit in another civil case, in the E. Jean Carroll case. And so the DC Circuit and the Second Circuit are parallel. They're the same level, and they are both ruling on presidential immunity in the civil context. And the reason to me, this was like a little confusing, or a little bit, I felt like it was a little bit of a head scratcher, was because on the one hand, the other cases, right, the Blasingame civil case and then the Chutkan criminal case, when they talk about presidential immunity, it's all about how, you've got Jack Smith arguing, we got to go to the Supreme. This is so important. This is so foundational. This is such a big deal. You've got Chutkan staying the proceedings. You got Jack Smith arguing that the Supreme Court should rush this and hear it, and it's such a foundational, important thing that we're going to leapfrog over the DC Circuit and go straight to you, Supreme Court. And similarly in Blasingame, right? Everything is about how this is such a foundational premise, and it's an all or nothing thing, right? It's if you're immune, there's no case. If you're not immune, you can go forward. I mean, it's truly that important, that foundational. This is not, some like interim small thing. And in fact, it's so important, which is why you're allowed to appeal while the case is pending, and you don't have to wait until after the fact. So you've got all these arguments being made by everybody about this issue being so incredibly important and foundational, et cetera. And then in the E. Jean Carroll case, I don't know how else to kind of sum it up, but the Second Circuit almost basically ruled on a technicality. I mean, that's what lay people would say, right? They didn't rule on whether or not when Trump defamed E. Jean Carroll, while he was president, they didn't rule on whether that was in the outer boundary of his job as a president. They didn't say, he's therefore not immune, or, whatever. They didn't rule on the merits. What they said was basically that you waived it. You waived it. You waited 3 years to raise it, which, again, if that was Alina Habba, I know that there was some issue that she didn't check the box, and therefore didn't get a jury trial in the Engoron case, and she got a lot of flack for that. And Judge Engoron actually came to her defense and said, that she did, he said she didn't forget to check the box. She got a lot of flack for that. But if she did this, this is a huge mistake. Like, this is like potentially, career ending kind of mistake. I mean, you represent a former president of the United States. This is a all or nothing premise, and you don't raise it. you forget, or for some reason you don't raise it. I don't know who made that decision or if it was a decision. But the Second Circuit basically said it was waived because he waited too long. And, they held that presidential immunity is waivable, and the defendant waived this defense by, waiting too long. And, and they cleared the way for Trump for the E. Jean Carroll case and it's really, I think it's just damages, right? The E. Jean Carroll one, because he was already found to be defamatory.
Yeah, punitive damages and consequential damages.
Yeah, so they ruled that can go forward in January, but then they go on to say that this is a case of first impression, and it's a vexing question of first impression about whether presidential immunity is waivable. And I don't know, just by calling it vexing, to me that just kind of, the whole thing opens the door to the Supreme Court saying, no, if you can waive it, you can waive it, but it has to be intentionally waived. You don't waive it by not raising it. And, it's not like forfeited, right? This isn't, you can't you can't lose something so foundational on a technicality. I don't know if the Supreme Court will rule it that way, but what I was hoping that they would have done was which they do all the time, which is we find that it's waived. But in the alternative, if it turns out it wasn't, we also rule on the merit. Like courts do that all the time. I don't know why they didn't do that here. And so I didn't love that.
Yeah. Well, we had a ruling last week by another court of appeal. Maybe this doesn't set up a conflict. The highest court in the land without a conflict to rule on the issue of civil immunity for a at the time president. That doesn't exist beyond the boundaries of his color of his office is Blasingham, the case that came down by the D.C. Court of Appeals. The Second Circuit is not at variance with Blasingham because it found, as the first court in the land to rule, that extending Blasingham, that it's waivable. The issue for me is not, as important or fundamental because it doesn't deal with criminal justice and it doesn't deal with somebody's liberty. If you force you and I talked about this before you and I got on the air. Donald Trump's name is so suffused with extra baggage that you almost have to eliminate him from the discussion in order to try to get some clarity in the analysis. If I said, for instance, John F. Kennedy, should he be forced to go through a trial where he was for things related to him being president, even things that may have been criminal? Or should the issue of immunity be decided first? People might say, well, maybe he shouldn't go through a trial, lose his liberty, and then find out whether he was immune or not. When it comes to money, which is all that, frankly, yes, it's justice. I don't want to belittle at all. E. Jean Carroll, Ruby Freeman, Shea Moss, those that are using the civil justice system appropriately to recover recompense money, which is really as Shea Moss. I think Shea Moss said it so eloquently and heartbreakingly. You got to hit them in the pocket because that's where they live, and that's why we have to do this. Then I'm less concerned about how big of a check he has to write to E. Jean Carroll and whether they got it right on immunity or not. And I think they had a set. For me, I don't think you can wait forever. Let's take it to an extreme. You go all the way through the trial. You go all the way to jury deliberation. And while the jury is deliberating, you stand up and say presidential immunity. Sorry, I don't like the way the trial went. I don't like the way that jury looked. I don't like the way the notes coming out of the jury looks for me. Presidential immunity, everybody. That's pretty late in the game. But if it's not waivable under this theory, then you just let it. And that's, I think, what they're worried about. They're worried about this pocket immunity that only pops up like they want it both ways. They want to double, like a person like Trump would want to double dip. I want to use the platform of this trial to convince the world that I didn't do those bad things to E. Jean Carroll. Oh, it's going south for me. Presidential immunity. Do it early.
Well, a judge, but in fairness, and again, a judge could, and they do this sometimes, a judge could put in an order that says if you happen to have someone who is president, you're suing a former president. In those limited cases, a judge could say, enforce them early on. If you're raising any immunities, including, these, you must tell me now, yes or no, and make them say yes or no. Okay, so do you waive that? Like you can force them.
Well, yes, but no, I didn't mean to cut you off. Go ahead.
No, I just think it's, I'm thinking of all the other reversible errors that exist in the law. And many times judges, what they do is they will make sure that it's that those rights are taken care of so that that type of thing doesn't happen.
Yeah, but you also had the unique situation where you had double E. Jean Carroll cases going on at the same time.
And you're right, civil is different than criminal. You are right.
You got two E. Jean Carroll cases going on. One was frozen in time. The other one went forward for a trial. Same judge. He went through an entire trial and lost. You and I on vacation reported about it in May and lost E. Jean Carroll, the other E. Jean Carroll case, about statements he made after he was president. And of course, he didn't raise immunity then because he couldn't. And then we restarted the case, but the case had been sitting around for 2.5 years. And then he said, that's a good time for me to raise presidential immunity. I think they're worried about the precedent. Of course, appellate courts always are worried about the precedent. How long can you wait for somebody to stand up, not play both sides, and assert their privilege? And I think they fell in love, right or wrong or indifferent, with the argument that was raised by one of the judges in the oral argument, which was, I could see a president wanting to waive, as you said, not win on a technicality and win on the merits about something that happened to him. I want my day in court. And so that's now the law. Now the Supreme Court will figure out whether they were right or wrong. I don't think it gets decided, frankly. They'll now, what's the next step people are asking? Donald Trump will move for a stay. They'll ask the trial judge to stay. The trial judge, Judge Kaplan's going to say no effing way. They're going to go to the back to the Second Circuit. The Second Circuit's going to say no effing way, and then he's going to have to try to take an emergency appeal through. Isn't the Second Circuit Sotomayor or Kagan? It's either Sotomayor or Kagan. We'll look at it.
It's Sotomayor.
Yeah, right, because she's the more senior. Sotomayor is going to go, sorry. And I don't think she sends it over to the full panel. She's like, click, no, sorry, flush, no appeal. See you later. You can take it up later after you lose. And I think that's where this is going to go. So that's the good news about E. Jean Carroll. Let's, in the time remaining, the two things I'd like to cover with you for sure is the New York civil fraud case, of course, and the conclusion of that case after 11 weeks, or to paraphrase one of the New York Attorney General's, Deputy Attorney Generals, we don't want more time, Judge. We just want this case to end.
But can I ask you one more question?
Sure, of course.
Sorry.
It's all right.
You know, the Supreme Court sometimes combines multiple cases on the same issue and decides that.
Yes.
Can they do that with criminal and civil? I only ask because they're really going to have 3 different cases involving Trump and presidential immunity, 2 civil and 1 criminal, literally at the same time. Can you combine criminal and civil?
I don't think so. I don't think they would from a jurisprudential standpoint. I think that's a danger zone to do that. I think they'd keep the bright lines between them. But you're right. They can say, yeah, these are similar issues. Let's throw them all together and we'll make one big fat decision and we'll watch them do that. We're halfway through their term. It started in October. Plenty of time left on the clock to make these decisions. And we don't have time today to talk about it. And it's not ripe yet for us, but they've just decided to take up a case related to Jan 6th and whether obstruction of Congress is an appropriate charge, often appealed by one of the Jan 6 insurrectionists, which if they rule against it would vacate hundreds of plea deals and convictions resulting in the Jan 6 insurrection world. So we're going to keep a close eye.
If you like that, you're going to love what we do every week on our curated podcast called Legal AF. Yeah, it's what you think. It's every Wednesday and Saturday at 8 p.m. Eastern Time. Live recordings. We're usually top 2 or 3 worldwide for YouTube Live at that moment. And then pick us up on audio podcast platforms wherever you get your podcast from. So if you know what I'm talking about, welcome back. Thank you for being in part of the audience for Legal AF. If you have no idea what I'm talking about or who I am, that was Legal AF. I'm Michael Popok, and join us. If you like that, come back, follow the whole hour-long podcast. And if you follow the show already, take that clip and send it to a friend, family, or somebody in your life and ask them to join what we're doing exclusively on the MeidasTouch network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.